Well, welcome back. My name is John Watts. I'm a consumer protection attorney in Alabama, and we're going to cover another question today. The question is, I've been sued by a debt collector and have trial in the morning. What should I do? And I don't know, maybe it shouldn't surprise me, but it's remarkable to me the number of times that I've had this phone call or had this message through my website or maybe a direct email. And this is somebody I've never spoken with before. And sometimes they say, hey, I'm having in like 45 minutes. What do I do? So I thought, well, maybe this video would be helpful. The first thing to do is to remember the difference in owing and owning. So you may owe on a credit card. The collection lawyer may be able to question you and establish that you took out this credit card, you used it, but you did not pay it off. So you owe the debt. That's where they want to stop, is right there. You owe the debt. So therefore, you owe my client Midland Funding, LVNV Funding, Portfolio, Unifund, Asset, Acceptance, whoever it may be. But that's not enough because you never borrowed money from Asset Acceptance, Midland Funding, Portfolio. You, quote, borrowed money from a credit card company who is not suing you. Instead, you have this debt buyer suing you, this debt collector suing you. And they have to prove that they actually own the debt. Now, if they can prove they own it, well, then they're in the same position as if it was Chase or Capital One or Citibank or whoever the original creditor is. But understand, this is an absolutely vital, critical difference. You may owe somebody, but that does not mean that you owe the company that sued you unless they prove that they own the debt. So let's look at the next thing, and this is really the fundamental principle when you're testifying in court. You tell the truth. You don't guess. You don't speculate. You tell the truth. That is your obligation as a witness, to testify to things that you have personal knowledge about. If you don't know and you go, well, sure, yes. Well, you may be wrong. You don't have personal knowledge unless you do have personal knowledge, okay? So if you know what the truthful answer is, then you say it. If you don't know what the truthful answer is, then you say that. So if I say to you, imagine I'm questioning you at trial, and I say, who sat 2 desks in front of you and 1 over to the right in 2nd grade on the 17th day of school? And if you remember that, I'm a little disturbed, okay? I'm assuming you search your memory and you go, I got nothing, okay? Well, what would the truth be? Well, the truth would be, I do not know. That's the truth. If you say Susie Smith or, Jeremy Brown or somebody else from your 2nd grade class, you're just guessing. That's not personal knowledge. And you're under oath. You have promised to tell the truth, so you can't just be making stuff up. Well, that also means when this debt buyer is trying to get you to guess, to speculate, to make stuff up about, they really do own the debt. My suggestion is don't do that. So let's look at an example. Bill of sale. So they'll say, now, you owe Chase and you agree you owe us. Go, wait a minute. I got to answer truthfully. No, I don't agree that I owe Unifund, Midland, LVNV, whoever it may be. They go, oh, well, we have this piece of paper here. See, it says bill of sale across the top. That proves it, right? You agree. Well, think about that. They don't have a witness there, and they have a piece of paper. And when you read the piece of paper, it talks about there's a purchase agreement. There are all these other pieces of paper with it. But instead, they just have this one piece of paper. And do you know that that's a true bill of sale? Do you know that if Midland bought the debt that they didn't sell it to somebody else? Well, there's no way you would know that. So to sit there and go, well, okay, I guess you guys bought it. Well, now you're speculating. You have no personal knowledge of that. That's some secret business deal between Capital One and Midland, or Chase and Midland, or whoever the company is. There's no way you could know that. Okay? So my suggestion is, if you remember, the fundamental principle of testifying is you have to tell the truth. When they put something in front of you and you honestly don't know, well, then say that. It's like the second grade question. You go, I don't know who sat, 3 people in front and 1 to the right on the 17th day of class, or whatever my crazy question was. I don't know. Well, what about it? They go, well, look, here's an affidavit of ownership. This is from Chase Bank, and it says we sold the debt to Portfolio Recovery or to LVNV. So there, that proves it. Well, first of all, if you're in district court, no, let me back up. If you're in circuit court, you really need to not be doing this on your own, okay? But if you're in circuit court or district court, then an affidavit is improper unless you don't object to it. Here's the easy thing to remember. There's this concept of cross-examination where somebody can come in and say something, and then you can question them about it to make sure that it's correct. How do you question a piece of paper? How do you cross-examine a piece of paper? You have no idea if this is true. And so you can't agree to it, and you certainly cannot say, yes, I think this is valid evidence. I mean, think about it. The big banks are the ones that did the robo-signing, where they'd have like 10,000 affidavits signed by somebody, or already notarized before they put any information. They had people that had died, and yet affidavits are still being cranked out. Or maybe they were alive, but you've got somebody who is literally, quote, signing, swearing under oath, personal knowledge. Remember our conversation? You testify in court, it's got to be personal knowledge. They had people signing these at like 1 every 20 seconds. And it says, I made a careful review of all documents, and I have determined that this amount is due and owed, and we bought that. That's just complete garbage. So these same banks are coming in now. They're giving an affidavit to the debt buyer, and the debt buyer is holding it up like it's the gospel truth. It's anything but the gospel truth, okay? And so you can't cross-examine a piece of paper. And look, you make your own decision if you're representing yourself. I'm saying, when I'm in court and I see one of these things, my first thought is, are you kidding me? Do you think that we would remotely believe that this is true? I want somebody in flesh and blood there that can look me in the eye and say, we sold it. Now think about this. Even if they sold it to Midland, how does that person know whether Midland still has it or Portfolio still has it? They have no way of knowing, because they supposedly sold it, so they don't have any say in the matter. And so you need somebody from Midland or Portfolio or LVNV there. Here's the bottom line. They need multiple witnesses in these debt buyer cases. And so they come up with the bill of sale. That was our previous slide. They do affidavit of ownership. You can only testify to things that you know are true. And I don't know how in the world you would know this bill of sale is true or an affidavit of ownership is true. And usually this question gets asked, well, what if they bring witnesses? How do I cross-examine them? What rule of evidence do I raise as an objection? Well, here's the thing. I can give you, if you have trial in 30 minutes or the next morning, I can give you a life preserver, or I can throw a whole bunch of stuff at you and you can drown in complexity. Okay? My suggestion is grab the life preserver. The life preserver is, hey, I am going to tell the truth. That's it. And I remember the difference between owing and owning. And so when this lawyer says, well, now don't you admit that we own this debt? No. The lawyer goes, well, tell me every fact you have that proves we're lying. I have no idea. Well, so you admit that we own it? No, I don't. See, that's their burden to prove. You don't have to disprove it. They have to prove it. And they try and do that with affidavits. Now, we'll say this little caveat. In small claims court, a judge can, but is not required, to accept an affidavit, and then they can give whatever weight they want to it. My experience has been that small claims judges in Alabama, when they're dealing with Midland and Unifund and these companies filing, Midland and Portfolio each file about 100 cases a week, that they're not real inclined to say, oh, sure, just flood our courts with lawsuits and don't send witnesses. That whole deal about an affidavit can be, that's really like two neighbors fighting. Maybe they get an affidavit or sworn statement from a witness, and you don't want that witness to have to come to court. It's not really for these professional serial litigants here, these companies that file hundreds and hundreds and hundreds of lawsuits every month. But look, that's up to the judge. Okay, but you can certainly make the argument, Judge, I can't cross-examine a piece of paper. But somebody goes, well, how do I cross-examine somebody? How do I object to this or that? I can't teach you all that. I can't take 20 years of trial experience and say, okay, here's what you do. You got 15 minutes, let me teach you. But I will say this, if you hold on to that principle, that life preserver of, I tell the truth, I don't guess, I don't speculate, I don't make stuff up, you will be so far ahead of the game. But if you try to cram in, this is my opinion, if you try to cram in all these rules of evidence and what about this and what about that, and let me figure out how I'm going to cross-examine some professional witness from portfolio recovery, that when I've seen people try to do that, they drown. And so my suggestion is, if you're doing this on your own and you're at the last minute, hold on to the things that are going to give you the biggest bang for the buck. Okay, so if you have questions, you have comments, feel free to put those below this video. You can certainly call us, 205-879-2447. Go to alabamaconsumer.com. You can contact us there. If you have other questions you'd like to see us answer, please feel free to get those to me. Again, my name is John Watts. I represent consumers all over the state of Alabama who have been sued. We also sue these debt collectors all over the state. And if there's anything we can do to help you, we'll be more than happy to try to help you. And if you are watching this video and you do have a trial in the next 15 minutes or in the morning, then I certainly wish you the best. If you're successful, give us a call. Let us know. If you're unsuccessful, give us a call. Let us know. Either way, we'll be glad to walk you through your options. If you lose, what do you do now? And if you win, and so many people are successful in winning these cases, then we talk about, can we sue the debt collector in federal court? So that is a much more pleasant conversation for you, because if we can sue them in federal court and we're successful, then they're paying you money. Okay, so it's a much better conversation to have. All right, well, I'll bring this to an end and hope this is helpful. Feel free to comment or like or share it. And thanks for watching, and see you soon.